Hello there, and welcome to the talk that we're presenting today on menopause, employment rights and issues. I'm Paula Rome. I'm one of the partners at Julian Solicitors. And I'm here to discuss this subject. The reason why we thought we'd include this in the series of talks that we're doing is that in 2019, this was becoming quite an issue. It has been overtaken by other things, such as the pandemic, but it is one of those things that I do believe is going to stay on people's radars and may well come back as an issue when things return to normal. We certainly had a couple of claims in which have been based on menopause, and I'll take you through firstly what menopause is, why it's an issue for employers, the legal issues, how we got involved with it as solicitors, and also some simple steps that you can take to try and protect yourselves and hopefully minimize the risks of any claims or any other problems within your organizations based on menopause. So the first thing I would say is, why are we even bothering about this? It's a woman's issue, isn't it? And yes, it does affect women. It's a hormonal issue. And certainly one of the things that surprised me when I started looking into this because of a claim that I had is just how far reaching the menopause is and how many women it can affect. On average, the menopause tends to affect women between 45 and 55, and it can last for 4 to 8 years. So already we've got quite a broad scale of time. However, it can start later than that and earlier than that. Technically speaking, the menopause itself is once the woman hasn't had a period for over 12 months. One of the issues that occurs with the menopause, though, is that there is the period of perimenopause, which is before the menopause actually officially takes place. And this can have similar symptoms. So we're not just talking about women between 45 and 55, but women potentially between 30 and over 60. So once you're into that number of individuals affected, it is quite a large proportion. ACAS, who've done quite a lot of guidance on this, have actually estimated that potentially 2 million women could be affected. So that can be a quite large tranche of the workforce. So it is something worth thinking about. And certainly in 2019, ACAS had started spending quite a lot of time and attention on this. I will apologise, though it's not my fault. I have linked into a number of the ACAS guidance and articles on this. One of the things ACAS is doing at the moment is restructuring its website. So you will notice that archived pages do keep getting mentioned. That's simply because at the moment ACAS have archived a lot of its information but not actually launched the new websites yet. So a lot of the information on the menopause and disability, when we get to disability discrimination, which I'll be touching on, have been pushed into the archive section, but they are still available and eventually will be updated onto the new systems as well. So the menopause then. I've said it's affecting potentially 2 million people. Why do we care? Because of the number of symptoms. And I've lifted out here from ACAS and also some other websites, some of the symptoms, and just running through them: hot flushes, sleeplessness, digestive issues, headaches, migraine, fatigue, irritability, memory issues, lack of concentration, anxiety, depression. And you can imagine if you have an employee who's suffering from those symptoms, even if just mildly, then it is going to impact on them. It's probably going to impact on co-workers and potentially going to impact on your customers and clients as well. And this is a potential 20+ year window where your employee or workers could be affected. Historically speaking, because menopause is just one of those things that doesn't often seriously get spoken about in the workplace. There's been a bit of an assumption that the employee in question is really just suffering poor performance. And historically, I think there has been a little bit of a habit for managers to say, this is a performance issue, they're just not performing up to standard. And this led managers to take the individuals affected through performance improvement plans or even down disciplinary issues. Um, and if you look at the ACAS guidelines on this, it's saying that the women in question, they're feeling ill, they're losing confidence, they're feeling stressed and anxious and depressed. So when you add in on top of those medical hormonal symptoms, the fact that the employer may also be sort of not deliberately, but effectively undermining their confidence in their ability to do their role, then it leads to a potential conclusion of women simply voting with their feet. And there's a lot of anecdotal evidence that senior women are leaving roles, stepping back from those high performing, high stress senior positions, which is a definite cost to organisations in replacing them, and also a massive loss of talent and experience from organisation. So it has that financial cost, even without looking at my bit where I come in, which is, of course, to do with the employment law issues. And the employment law issue, where we've seen cases starting to arise, are in what we call the protected characteristics, so the Equality Act. And of course, describing the menopause, it's affecting women, protected characteristics, it's having an impact on their health, potential disability related protected characteristic. And although the age range is wide, it is still age related to some extent. So potential age discrimination there as well. And certainly one of the claims that I've got ongoing at the moment, the individual in question has raised sex, disability and age discrimination against my client, her employer, in relation to menopause symptoms, which she says affected her performance, which then in turn affected her selection for redundancy. So that's the sort of angle that we are starting to see claims being made within the employment tribunal process. And the problem with the Equality Act and discrimination is the sheer breadth of protection that's given to individuals. So we have direct discrimination rights, indirect discrimination, harassment and victimisation, which goes alongside most types of discrimination. And then, as I'll go on to talk you through, there's also special protection when it comes to disability. So to pick up the general types of discrimination protection first, direct. It's because of your age, it's because of your sex, it's because of your disability. Less common, most employers tend not to fall within that trap, although some still do. The indirect discrimination is more complex and difficult. This is where you have a provision, a criterion or practice, a rule that's applied overall, but it puts one particular group and persons within that one particular group at a specific disadvantage. And you can't objectively justify it. We will come back to objective justification, but in short, it is having a good business reason which you have thought through, and there is no less discriminatory way of achieving that good business reason. But we will look at that in a little bit more detail. Then you have harassment. And with the menopause, this is one of those areas where occasionally we do get claims. Jokes are made, which possibly 10, 15, 20 years ago, people would have got away with. It wouldn't be seen been seen as discriminatory in the same way. But quite frankly, making fun of people because of physical symptoms such as hot flushes, their age, those sorts of issues could well be violating the dignity and of that person and creating an intimidating, hostile, degrading, humiliating, or just plain offensive environment. And with menopause, as we said, that could be related to the sex of the person, the age of the person, the disability. Also, specific sex discrimination protection, unwanted conduct based on sexual behavior, and it can be based on the perception of the complainant. So if a woman complained about being warm and somebody turned around and made some comment about it being a hot flush, even if she wasn't menopausal, potentially the legal protection is there. Victimization, one would hope we wouldn't get near this point, but just for total detail, victimization, this is where someone has raised a complaint or given evidence in a complaint and then is treated to a detriment because of taking that protected act. So raising the complaint itself. And hopefully if somebody came to us with a concern about jokes about menopause or being teased because of hot flushes, hopefully we wouldn't discipline them because of that, although we will look at a case as we go along which does raise questions about how employers behave in this situation, but one would hope we wouldn't get near that victimization issue. So disability, I promised you a little bit more information on disability discrimination. Personally, I think disability discrimination is one of the most difficult areas for employers. It's got those initial protected areas that we were talking about, direct, indirect, harassment, victimization, but it's also got extra levels of protection, what we call the Section 15 protection. And this is where someone is discriminated against because of reasons arising from a disability, which cannot be objectively justified. So I have the menopause, it makes me forgetful. Because I'm forgetful, I make a mistake at work. You discipline me because of that mistake. You wouldn't think there's a connection there, very clearly a connection to a disability. But if I can trace back that mistake to the symptoms, to a disability, which is menopause, then I do get that protection. You have the defense, and that's where this objective justification is quite useful, to say that, well, we were protecting the quality of the work. But the question that the tribunal will ask is there no other way that you could have taken steps to protect the quality of that work, which were less discriminatory in relation to the disability? So it's quite a tough test that's there. Another tricky area, the duty to make reasonable adjustments. And if you have a workplace where people are embarrassed or feel unable to even talk about menopause, and line managers feel uncomfortable if it's mentioned, then in all probability, you're going to struggle to say that you took the steps necessary and sort of complied with that duty to make reasonable adjustments, because it's simply not been discussed even. There is one positive here for you. If you do decide to take steps to protect individuals, women, going through the menopause, you are allowed to positively discriminate. It's the only area in relation to discrimination law where you can choose to positively discriminate, but that is allowed in law. So you needn't worry about the issues of a man saying, well, how come she gets that protection, I don't? You are legally entitled to positively discriminate. And disability, why are we so concerned about menopause falling within the protection of disability? And I've mentioned the definition at the end of this slide and the beginning of the next one. And the problem with disability discrimination and disabilities is it's such a wide definition. Any physical or mental impairment, which has a substantial and long-term adverse effect on a person's ability to carry out day-to-day activities. And we can break that down into certain section. So physical or mental impairment, I think it's pretty clear that the menopause is a clinically well recognized effect, impairment on that individual. So what would a woman have to go on then to say? That it does have a substantial effect on her. Menopause has no symptoms on some women, but on other women, it will have an impact. Quite often, the impact is offset by the fact that the woman can have hormonal treatments and they can fully rectify any impact that the menopause is having. But for the purposes of the Act in this definition, we look at the individual, the woman concerned, as if the drugs or equipment is taken away. So the tribunal, if they were assessing this, would look and say, without the drugs, the hormonal treatment, what would the effects on the individual be? And if they are stress, depression, migraines, inability to concentrate, memory lapses, potentially all of those you can see would have a substantial effect on that woman's normal day-to-day activities. And the last point, is it a long-term effect? Is it going to last for 12 months or more? Well, on the first slide, some of these symptoms can go on for 4 years or more. And I don't think it's too much of a stretch for a doctor or a GP to say, well, we think, yeah, definitely this is going to be 12 months or more. If you have any questions, again, I give my apologies, it's in the archive section. But ACAS put together a really good guidance note on how to assess if somebody is disabled, which gives a lot of really good practical examples of what they would look at. Fair to say that we do have case law that says that menopause can, in some situations, equate to a disability. And if we do have a disability, then we've got, as we said, most probably these types of discrimination, indirect discrimination and discrimination arising from a disability, which can be objectively justified. As I said earlier, also objective justification, it does give you a defense. So you're not lost. But the problem with objective justification is that having a good business reason alone is not enough. What you've then got to convince a tribunal is that not only is it a good business reason, but it's proportionate, appropriate, and necessary. They don't like money alone. Cost alone is one of those sort of reasons that the tribunal get a bit twitchy. If you've got cost and another reason, we call it cost plus, then those reasons together, the tribunal will look at and be a lot more sympathetic. But cost alone is one that they don't like. And the question they will be asking you is, right, you've told me that client satisfaction or having people in work for a certain start time is important to you. Is there a less discriminatory way you could have achieved the same outcome? So just to work this through from the beginning for you with an example, it's not an actual case, but just something that occurred when I was preparing this. Say we have a woman who isn't sleeping well because of the menopause. Because of that, she's fatigued and she's finding it hard to get in for your 9 o'clock start. You need a 9 o'clock start because that's when clients start ringing in. So your response to the woman in question when she starts being 10-15 minutes late regularly is to put her through a disciplinary or a performance management process. She complains about this and says that, well, this isn't fair, it's because of my menopause. or is too embarrassed to tell you it's because of the menopause, but assuming that she does, it's because of my menopause, I'm tired. Your reaction to that is, well, we're fully sympathetic to that. We'll do what we can to help, but we need people here on 9 o'clock because that's when the phones start ringing. I'm afraid that sort of you do need to be there. If you don't, we'll have to take this further. She doesn't take it further, or she doesn't improve, and we take it further to a dismissal, or she loses her temper, walks out, claims constructive dismissal. And disability discrimination. Would we have a good business reason for saying you've got to be there for 9? Probably yes. We've got clients who ring in and they want somebody there to answer the phone at 9 o'clock. Have we been proportionate and taken the steps which are appropriate and necessary? If we haven't looked at how we might be able to achieve the same result without requiring her to be there at 9 o'clock and giving her a little bit more flexibility, then we probably haven't met the test for objective justification. If we haven't looked at, can we cover the work with other people? Is there a phone message system we could put in place to just give her a little bit more flexibility? Then we probably haven't gone far enough. If she's a one-person team, there's no one else can take the calls and there's no other way around the situation, and you'd considered it and discounted it, you probably would have gone far enough. But you would need to be able to say that you had taken into account those considerations and discounted them, simply rather than taking her straight through a disciplinary process without the broader consideration. So that's how objective justification works, and it can be quite tricky because of that last step of, is there any other way we could have achieved this? So looking at the case law then, when the employer gets it horribly wrong, this is an employment tribunal level decision, so it's not binding in the same way that an employment appeal tribunal or Supreme Court decision would be. Ironically, it's against the courts and tribunal system themselves, and it was a lady, and you do get the feeling there's more behind this than is just reported, but it's the lady in question who was perimenopausal. She wasn't officially in menopause yet, but was receiving treatment for her menopause transition symptoms. She was suffering from heavy bleeding, stress, memory loss, and other symptoms. She put her medication in the court and couldn't quite remember what she'd done with it, whether or not she'd put it in the water in the court, or she'd taken it, or she hadn't put it in the water. And she got very confused about this. Her two colleagues who were in the courtroom started to drink the water, despite her having said to them, please don't. You get the feeling they were deliberately winding her up, reading between the lines. But she was quite abrupt with them, quite rude to them. As a result of that, her employer took the view that she should be disciplined, and took quite a hardline view on this, considering that she'd lied, which seems a little extreme, and brought the court into disrepute when she'd advised her two colleagues that they shouldn't drink the water because it might contain her medication. And Ms. Davies was sacked. She was dismissed from her role. She took a claim of unfair dismissal and also discrimination, that's Section 15, discrimination arising from disability. The Employment Tribunal claimed that her dismissal was because of conduct arising from her disability, but they could objectively justify why they had done what they'd done. And her employer argued that the reason that they had taken the steps that they had is that they had a legitimate aim, which was having honest and trustworthy staff. The Employment Tribunal said, well, yes, that could potentially be a legitimate aim, but we do not see that sacking somebody who is alerting colleagues to the fact that her medication might be in the water in the court is an appropriate or proportionate measure of achieving that. So the dismissal seems totally out of sort of context when the woman in question was just telling two of her colleagues not to drink the water, and genuinely had provided evidence to say that she did suffer from memory loss and confusion, so could not remember if her medication was in the water or not. So it does seem, looking at it, like an overreaction by the court. And the tribunal service in Scotland decided that the tribunal service in Scotland had overreacted in dismissing her in these situations. But it's an interesting case because it clearly does show that, firstly, menopause can be a disability. And also, if the employer reacts badly to this, or uncautiously to this, it could result in unfair dismissal if they've got over 2 years qualifying experience, and also, more importantly, disability discrimination. So on my final slide, how do we avoid this happening? One of the things that was very much mentioned in 2019 and became quite fashionable was, let's have a menopause policy. There's nothing wrong with having a menopause policy, and I think it is potentially a good way of opening the subject for discussion, because one of the problems is that menopause is still just not mentioned in a number of workplaces. Line managers won't mention it. They're embarrassed about it. They don't feel comfortable in having that discussion or conversation. Putting in place the policy might help. It at least opens the discussion between staff, managers, and HR. But even without a policy, I don't think there's anything stopping an organisation on health and safety or general well-being grounds having conversations about menopause, creating an environment where women are prepared to talk about symptoms, and not just as a joke that's sort of being passed around along colleagues, or pigeonholing themselves as that difficult member of staff who always wants to sit in a certain place in the office. Raising awareness of the symptoms. I must admit, until I started looking into it, I wasn't fully aware of the full range of the symptoms or the impact that they could have. Educating co-workers and managers about the impact, maybe doing risk assessments. If you have women in the workforce, for looking at some of the figures earlier on, over the age of 30, then you're going to as soon as you stop looking at risk assessment for potential pregnancy, start looking at risk assessment for, well, menopause is next on the list where the hormones come into play. What support, what assistance can we put in place? Are there any simple adjustments that can be put in place? Low cost. How about a desk fan? Overheating, the constant arguments about how hot or cold an office should be, which go on with or without menopause, maybe can be made less embarrassing for people if desk fans are just made available so they can have some control. Home working may well have minimize this risk, but as people go back into the office, it's going to be back on the agenda. You can't just throw this over to your HR teams. Really, line managers are going to be the first people who notice if there are issues. Having confidentiality and letting people know if they want to talk about these symptoms, then it will be handled confidentially. And if women are really struggling with the symptoms, occupational health advice, have we got that available? Or helpline support so they can talk to people about how they're feeling. The point I'm saying is, the first step is make women comfortable so that if they are having issues, they can talk about them. The last thing you want to happen is that women feel embarrassed, uncomfortable, and leave, because you can be losing very well qualified staff who are very hard and expensive to replace. Also, speaking as a lawyer, what you don't want are claims coming in from women who feel they've been belittled or not heard, which is another risk. And everybody wants a workplace which is nice, comfortable, that allows employees to succeed. And this is just one of the pieces of the jigsaw that you can start to put in place and have at least conversations about menopause and just how far reaching the effects can be. So I do hope that has been useful for you and is helpful. It's not a subject we often talk about, but one that's certainly worth considering as we start getting people back into offices and office spaces. And I hope that you can join us for some of the following presentations and sessions that we will be doing for the rest of the series. Hope that was useful. Thank you ever so much for joining me today.